We simply cannot allow people to pour into the United States undetected, undocumented, unchecked.
And complete the dang fence.
This bill that we will sign today is not a revolutionary bill.
Cast down your bucket where you are.
We come from France.
And I am, adamantly against illegal immigrants.
They're coming in by the thousands, just unbelievable.
A wall is an immorality.
Who are you rooting for?
Those masters of the universe are at it again.
You maniac! You blew it up!
Welcome to Parsing Immigration Policy, a podcast of the Center for Immigration Studies. This is Andrew Art Arthur, resident fellow in law and policy for the Center for Immigration Studies, guest hosting today for Mark Krikorian, and we're honored to have with us as our special guest, Andy McCarthy. Andy writes for the National Review. He's a contributing editor over there, and he's a frequent contributor to Fox News, probably familiar to most of the people listening today. Just to give a brief intro, if we were to do the full intro, I'd take the whole time. Andy started out as a deputy U.S. Marshal on the Witness Protection Program. We could probably do an entire show just talking about that, but I think Mark might be a little peeved at me at the end. And he spent 18 years as an assistant U.S. attorney at the U.S. Attorney's Office for the Southern District of New York, the premier U.S. Attorney's Office in the United States, which I'm sure he would agree with. And he actually did a lot of great work when he was at the U.S. Attorney's Office. He was involved in the prosecution of the first World Trade Center bombers, the blind Sheikh Abdul Rahman, and his co-conspirators. And he also, when working for U.S. Attorney Rudy Giuliani, participated in the Pizza Connection case, an effort to bring down the mafia in New York. Andy, thanks so much for joining us today.
Art, thank you so much, and thanks for the kind words. If I know anything about immigration law and policy, it's because I'm a faithful reader of yours and Mark's, and it's a pleasure to be here.
Well, honestly, the honor is mine. Listeners could probably hear it in my voice, and truly a big fan. And, I would advise anybody who really wants to understand the world of law, particularly lawfare and everything that's going on these days with respect to the Trump administration, to follow Mr. McCarthy at National Review. So to begin with, I wanted to jump into some key concepts that, we talked about a lot under the Biden administration. The first key concept is prosecutorial discretion. For our listeners, prosecutorial discretion was the argument that the Biden administration made when it opted not to enforce the immigration laws, when it opted not to take individuals into custody, to detain them, to prosecute them, and to remove them from the United States. Every federal prosecutor has probably read a great speech given by then Attorney General, later Justice Robert Jackson in 1940 called The Federal Prosecutor, that talks about what an awesome responsibility being a prosecutor is, but more importantly, how key to prosecutor success prosecutorial discretion is. So, Andy, I was wondering if you could give us your perspective on prosecutorial discretion, especially under the Biden administration.
Well, Art, I actually take what the Biden administration did back to the Obama administration, particularly with DACA and DAPA, and I don't know if there's a DADA or something else I'm leaving out there, but what I think where this went off the rails is Obama's perversion of prosecutorial discretion as a rationalization for not enforcing the law. Up until that point, I think, there are obviously outliers over the years, but prosecutorial discretion is really just a resource allocation doctrine. It's just a realistic understanding that there's so much crime and there are finite resources to address the crime. So what the government attempts to do, if it's operating correctly, is to try to target the limited resources at the biggest problems and to do it in a way that you get as much bang for the buck as you can, in the sense of trying to do the biggest cases impact-wise that you can in order to create an effect that discourages criminal behavior, out of the recognition that you simply couldn't, if you wanted to, prosecute every single crime that gets committed. And in fact, nobody would want to live in a society where that happened. So it has always been in the United States a system where the prosecutor has unilateral discretion to bring a case or not bring a case. Can't be ordered by the court, can't be ordered by Congress. It's completely an executive branch call. And when it's operating properly, it's a case-by-case exercise where you weigh the merits of the prosecution, including obviously the seriousness of the offense and the effect on any victims, et cetera. And then the other side of the ledger, like, are we dealing with a first offender? If it's a fraud case, for example, is it underneath our normal guidelines for fraud? Because again, even though all fraud, if it uses the mails or interstate commerce mechanisms, all fraud is a federal crime. But since you couldn't possibly prosecute all fraud, the government imposes, as a matter of discretion, certain thresholds under which they won't normally prosecute unless it's a particularly bad offender, in which case those things go by the board. So as you could probably tell, it really is, when properly done, an inquiry that looks at the individual case and the merits of bringing it or not bringing it. What Obama did, in particular in the immigration field, but not only in immigration enforcement or non-enforcement, as it were, was reimagine prosecutorial discretion as a reason not to prosecute broad categories of cases. And they would call it prosecutorial discretion, but I think it was really a violation of the Constitution for at least two reasons. One is it's basically rewriting, it's a usurpation of Congress's authority to write the laws. If the president just says, I'm not going to enforce these drug crimes or these immigration crimes, these are laws that have been enacted by Congress and the executive is supposed to enforce them, which brings me to the second constitutional concern, which is that the president takes an oath to faithfully execute the laws. So if you are, in a categorical way rather than a case-by-case basis, taking swaths of statutes that Congress has enacted and just deciding that you are not going to give the force of executive enforcement to them, that's a violation of the duty to faithfully execute the laws. And I think in the Obama days, if you recall, you probably recall this better than I do, Obama said again and again and again that he couldn't give various kinds of relief that were being asked for, I think mainly with respect to dreamers, but other categories of immigrants as well. And after again and again and again saying that he didn't have the authority in our system to just give them amnesty, basically he gave them amnesty when Congress would not react to his desires by legislating the things that he wanted enacted into law. And I think if you look across the board at the Obama Biden administration and the practices of its Justice Department, and even a lot of people who were personnel in the Justice Department, really the Biden administration was the third Obama term. And it was certainly just an extension of what had been the Obama-Biden Justice Department. So I think you saw a lot of the exact same policies from one administration to the next, with the interregnum of Trump in between. And I do think, if anything, the pace of lawlessness picked up, in the sense that Obama, for all he did in forging prosecutorial discretion as a rationalization for not enforcing the law, at least at the beginning, he tipped his hat to the idea that he did have to enforce the law, and that there were some things that he didn't have authority to do. And I think that kind of went by the boards during the Biden years.
Yeah, that's definitely true. If you take a look at the earliest prosecutorial discretion memo that came out of the Obama administration, what we referred to as the Morton memo, which under the guise of prioritizing immigration enforcement put certain individuals who are unlawfully present or who had committed crimes that rendered them removable from the United States off limits. And that then expanded under the J. Johnson memo, which was issued in November 2014 and reached its apotheosis when Secretary Mayorkas issued his guidelines on immigration enforcement in September of 2021, basically handcuffing ICE officers and their ability to arrest people. It's interesting, Andy, because when you look at, all of these high-profile arrests that are going on, Tom Homan and DHS Secretary Kristi Noem out on the street, pulling rather notorious criminals, off the street into cars and out of the country. Those are all individuals that were known to ICE at the end of the Biden administration. They just didn't touch them. And, I think that that's a point that's lost. It's not like these people suddenly showed up on ICE's radar once Donald Trump took office. They were already here. They were just not priorities under, the Biden prosecutorial discretion regime for prosecution. There's another concept that I think we're going to hear more about, and that's the Supreme Court's emergency docket. And of course, most people think about the Supreme Court's merits docket where, it issues 2 decisions or 3 decisions a day during the term, for certain days during the term, and it makes a big splash. But there are a number of cases that are sitting on that emergency docket, again, which is often derided as the shadow docket by people who don't like the way that it turned out. Trump versus Washington, Trump versus New Jersey, Trump versus DACA, all of which involve birthright citizenship. And a case I hope we get the chance to talk about, Trump versus JGG, which involves the Alien Enemies Act. Could you talk about the emergency docket, how the Supreme Court uses that, and, what to look for as it starts to hand down decisions on that docket?
Yeah, it's interesting. The pickup of activity in the emergency docket is a symptom of what I think is overall dysfunction in the justice system, and probably underlying that overarching dysfunction in that Congress doesn't do its job anymore. So the courts, more often than ever before, have become the forum in which there is an attempt to check executive power because Congress isn't doing it effectively. Most of this arises out of this idea of nationwide injunctions, because that's the pot of gold that these both special interest groups, the legal component of them, and these confederacies of state attorneys general, one for the blue team, one for the red team, what they're trying to do once a president either tries to enforce a policy or even an interpretation of a congressional statute, rather than the old process where there would be a million cases and the issues would crystallize over time, things would percolate and make their way to the appellate courts and then ultimately up to the Supreme Court, by which time usually a couple of years at least had passed and you had a real sharpening of what the dispute was by the time it got to the court of last resort. What you now have, Art, instead is kind of a race to the courthouse by special interest groups who've picked out judges that they think will be particularly sympathetic to their point of view. When the Republicans are in, the Democratic lawyers run to New York or to Washington or to California or places where they think there's a number of Democratic appointed judges who are likely to see things their way. When Biden was in, and also when Obama was in, Texas tended to be the place where lawyers would gravitate to challenge policies for the same reason. But just to give you an idea of how the pace of this has picked up, there was not a nationwide injunction. And I guess I should stop and explain what that is. that's when a single district judge, unaccountable, politically unaccountable, electorally, with no responsibility for immigration enforcement, foreign policy, or national defense, issues a ruling that doesn't just purport, it actually does have the effect of halting a policy and thereby affecting not just the parties in the lawsuit, but everybody in the entire country. And that has the effect of freezing things until it is either undone by that court or by a higher court, which is something that can take a number of years to play out. From 1789, when constitutional governance in this country began, until 1963, we had no instances of federal judges issuing nationwide injunctions. We've had about 127 since then. You have to keep revising the number because the pace has picked up. Out of the 127, over half, about 64, were issued during Trump's first term, and we're seeing the pattern continue into his second term. And one of the dysfunctions for the system that this results in, to get to your point about the emergency docket, is a district judge issues an injunction that says the executive branch cannot enforce a policy, which basically supplants the unelected judge's policy preference for the elected presidents. Obviously, the administration isn't going to stand for that. Neither administration, whether it's Republican or Democrat, would stand for it. So what they try to do is rapid fire, get it up the chain in the court system. And the result is that rather than coming to the Supreme Court in regular order, usually cases take about 2 or 3 years to get to the Supreme Court as they work their way up from the lower courts. You get right to the Supreme Court in a very rapid fashion, much to the disquiet of the court, because when cases get to the court in that way, the record is not developed. The Supreme Court is a court of last instance. It's not a fact-developing court. It's not a court of first instance or a trial court. So what has the judges upset is that these cases are getting to the court with a kind of a half-baked record, and in the rush to deal with very complicated issues, often you're not giving them the kind of time and thought that you would normally give in order to work your way through a complicated legal question. So it's wrong on just about every count, in the sense that we don't have democratic self-determination. We basically have unelected judges making decisions. Instead of the public being represented, it's special interest litigators who are represented. The judge makes the decision, which means the unelected official, rather than the politically accountable government, is actually running the country. And when the cases get to the Supreme Court, the court often doesn't want to take the cases because the record is not ripely enough developed. And it's very concerned that when it does take the cases, that errors could be made, because when you don't have a crystallized understanding of the facts, and when the legal issues haven't been fully played out in a sharpening kind of way, that's when you tend to make errors. You know, when those get on the books, they have a corrupting effect on the law.
Yeah, and there's a statistic that's making its way around Twitter and the internet that about 2/3 of all of those federal district court judges currently sitting in the country were actually appointed either by President Obama or by President Biden. Of course, you used to get older attorneys make those individuals district court judges, but I guess we've all sort of, learned the game, and now we get the brash young upstarts, put them on the bench, and they could be there for decades. And again, I always hate to allude to Obama appointed or Biden appointed or Trump appointed judges, but, they do seem to have different political philosophies. They do seem to see the world differently. Do you have any thoughts on that?
Well, I think there's a cultural change in the law. Two different threads. One is sometime in the, particularly in the mid 1960s, I would probably take this back to before the New Deal. There was an interesting biography written by a guy named Snyder of Justice Felix Frankfurter a year or two ago that tells the story well. But you saw a real change in the culture of the law, in that the study of law up to a certain point was about mastering treatises and jurisprudence with an eye toward undergirding the rule of law, with the idea that that framework is what's necessary for a flourishing free society. I think in the 20th century, as it went on, you got more of a current of thought that the law was a tool or even a weapon of social change. And you had much more in the way of progressive activist lawyering than this idea that, they're there to change the system, not to undergird the system. And I would say in the late 70s into the 1980s, you got this very different thread, which is basically the Federalist Society, but the idea of promoting the legal philosophy of originalism, that the law, both the Constitution and statutes, mean what they were understood, what the public understanding of them was at the time that they were either ratified or adopted. And that obviously is a very different and kind of restorative way of looking at the law. So you have, I think, camps of two very different kinds of lawyers. Although I would say, and I'll put my priors on the table here. I'm obviously a conservative lawyer of an originalist bent, so take that for what it's worth. But I do think that progressive lawyering is more dangerous than to democracy and to our constitutional republic than conservative lawyering, because I think conservative lawyering is mainly concerned about the process and making sure that the decisions made in our constitutional republic are made by the component of government that's supposed to make them. So a conservative legal philosophy and originalist judging doesn't get you to necessarily conservative results. What it basically says is you can have whatever policies you want, including progressive policies, but they have to be decided in an accountable way, the way the Constitution is set up, which means that the political branches are supposed to be making most of the decisions. And I think progressive lawyering is about getting to particular progressive results. So if you have to make the separation of powers argument to get to the result you want, you make that one. If you have to say the separation of powers has been overridden by progressive governance, you go with that one. If you need text, you go with that one. If text doesn't work, you go with a different one. But the whole idea is to get to a result and then reason backwards to how you get to it. And to me, that's more corrupting of the constitutional order and the republic. So those are the two different philosophies that we have. And since most of this, we're talking about the emergency docket and nationwide injunctions, what it means is that a lot of what should be democracy is getting played out in the courts. So, the activist lefty groups are finding the activist lefty judges to get the results they want. The conservative activist groups go for the originalist judges in the hope of getting the result, or at least the process that they want. So that's the dysfunction of the legal system. But I don't think we can just entirely blame the legal system. So, for example, you could complain, and it would be a viable complaint to some, that President Trump, especially in his second term, which we're only into about 100 days of it, he's being stopped left, right, and center by judges. And I think that's if you want to take that critique at 10,000 feet, that's true. On the other hand, Trump is trying to do some very radical things. It looks like his administration is purposely trying to pick fights in the hope of getting rulings that will be pushed up to the Supreme Court because there are major building blocks. For example, a 1935 Supreme Court case called Humphrey's Executor, which is a major building block of the administrative state and progressive governance in the United States that radically alters both our conception of separation of powers and the imposition of restrictions on how the president could run the executive branch. They're trying to get those cases pushed up to the Supreme Court. So they're intentionally picking out things that obviously judges are going to have a problem with, because you have to get rulings like that in order to stir the controversy to the point that it gets risen up to the higher courts. So yes, the judges are stopping Trump, but he's also doing things that are intended to create controversy by, for example, we have a TikTok law that directed that TikTok had to divest. Trump came in and said, we're not going to follow that law. He didn't really have any authority to do that, but he did it. There's a lot of civil service protections that limit the president's ability to terminate federal employees. These are laws that come out of the 1970s. Trump is trying to fire federal employees. He's trying to shut down agencies that were created by Congress. And there's a lot of issue about whether he has the authority to do that. If they're agencies that do foreign relations, which the president probably has pride of place in our system, like USAID, maybe he has authority to shut them down, even though they're created by Congress. On the other hand, if it's the education department, which is an area of domestic statutory and regulatory law, meaning that it's where Congress has pride of place, it's very doubtful that the president has the authority either to shut down spending or to shut down entire departments. So you can't just go by raw numbers. You also have to look at what it is that a president's trying to accomplish. And if a president is being provocative, I guess we should expect that we're going to find a lot of these controversies.
Yeah, and I think that's a great segue into, the next thing that I wanted to talk about. You had written in the National Review a few days ago why Trump must tread carefully in deportation cases against legal aliens. And we've seen the Trump administration utilize some powers that, always existed, but really weren't used in the immigration context that often in the past. One is the foreign policy ground of removal, where the Secretary of State can determine that an individual alien's presence or activities in the United States poses a risk to the foreign policy of the United States, which gives the Secretary of State the authority to then take away that individual's status. They still have to go through removal hearings, but it's a pretty powerful tool. And the other is the use of the Alien Enemies Act. The president has used that 1798 law to remove individuals who are members or alleged members of the Venezuelan crime organization Tren de Aragua. And you definitely have some opinions on the use of those authorities, and I'd like to hear them.
Well, I think, Art, to take the first one first, the foreign policy exclusion, I think that's the most edgy thing as far as what you're asking the courts to enforce, because it almost feels un-American. What you're ultimately saying, and I should say up front, I support this, but I'm trying to make the case against it so people understand how edgy it actually is.
The best lawyers can argue both sides of an issue, Andy. Go ahead.
Okay. So you'll get my double bill at the end of all this then. But, what you're basically saying is that if you're talking about an alien, no matter what class of alienage we're talking about, when I say that, you are much more expert in this than I am, but we're talking about like a sliding scale where you go from the lowest ranking alien in the United States, which would be somebody who is illegally present here, up to the highest status, which is lawful permanent resident alien, a green card holder. What you're basically saying in this thicket is that no matter how high the immigration status is, and some of these cases involve green card holders, some of them involve people who are here on student visas, work visas, so people who are here lawfully. What you're saying is you can throw them out of the country, you can expel them, you can remove them on the basis of activity that would be First Amendment protected if it were activity engaged in by a citizen. So you're talking about speech and association. The law allows that with respect to aliens because it commits the decision whether somebody is allowed to be here or not to the Secretary of State and basically to the executive branch, not to the court. And the way Secretary Rubio has described this, I actually think it's got a real logical appeal, even though when you analyze it closely as a legal matter, it breaks down. But what Rubio says is that anything that you do as an alien that would give us a rationale to keep you out, to exclude you from entering the United States, should be something that would also give us the right to expel you from the United States if you do it when you're here. I like that idea. It's logically symmetrical and sensible. The reason I think it breaks down legally is the Supreme Court has said, really since the 1950s going forward, that the alien has basically an ascending scale of rights, which ascends as the person deepens his connection with the United States. And the way I would think about this is exactly that scale that I talked about before. If you get somebody who comes into the United States illegally or illegally, but over time adjust status upward so that you get a work visa or a student visa, and then you're ultimately say you marry an American citizen, get an adjustment of status to green card holder, and you're on the trajectory to become a United States citizen, since that's how the process works. As you ascend that scale, your due process rights increase. Now, they don't exactly mirror the due process rights of citizens, although even that's a kind of a complicated area because, for example, in the criminal justice system, if we bring anyone in, whether it's an American citizen or an illegal alien, there are due process rights that everybody who is accused of a crime in America gets, and the government has the same burden of proof, no matter who it is that the government is prosecuting. But in many contexts, your rights do increase as you become, it's much easier to remove an illegal alien than it is to remove a lawful permanent resident alien. So that's what we're saying here in this area, is that even if you have the highest level of rights as an alien, the Secretary of State can boot you out of the country. I think the law does reflect that, but I think the administration is wrong to think that there is no difference between, say, a lawful permanent resident alien and an alien who is outside the United States and has never entered the United States and whom we're trying to exclude from entering the country. It may be logically true that those two things, the things that would keep you out should be the things that allow us to kick you out. Maybe that's so logically, but I don't think it works in the way of, as far as the Supreme Court's sliding scale or ascending scale of rights is concerned. So I think the administration has to be a lot more careful than it's been in terms of its programs to try to boot out what are now what they're targeting at the moment are Hamas supporters. And Hamas supporter is a term that's easy to kick around in a cavalier way. It's important to remember that if they were actually Hamas supporters in the sense of having provided material support to Hamas, they would probably be prosecuted criminally. So if they're talking about Hamas supporters, but they're people who haven't been charged for supporting Hamas, then the likelihood is that what you're talking about is activity that would be constitutionally protected if an American committed it. And that's a dicier proposition as far as the courts are concerned, in terms of booting people out of the country. I want you to have a chance to comment on what I just said, and then maybe we can get to the Alien Enemies Act after that, if that's okay.
Yeah, absolutely. As a former congressional staffer, I always have to defend statute. And as a person who, in my youth had a very tangential relation to one of these cases, I do have to note that there is an exception in the law that nobody really ever talks about. And that is, for this foreign policy ground, if the ground is premised upon statements or activities that would be lawful in the United States, it then boosts it up a level for that ground of removability. The Secretary of State himself, Marco Rubio himself, would have to make a finding that it compromises a compelling foreign policy interest, that the alien's continued presence or activities or statements here would compromise a compelling foreign policy interest in order for that ground to be effective. I think we're probably going to see that play out in the case of Mahmoud Khalil, who's Columbia University grad student or graduate. It's probably the most high-profile individual that this ground has been used against. I think we're going to see that play out in the courts. But I actually think that the Trump administration invites, to your point before, that being discussed in the public forum, because most people don't really know what's going on at Columbia University, don't know what the protests are really about, and that'll give them a forum at which they can talk about that. But yeah, I do think, and, there's also there's a legal and then there's a political aspect to all of this, because, there is always the concern that the public will turn against some of these cases. Treading carefully, I think, is definitely good advice. And, I will link to your stellar article in the show notes. But your points are well taken. But since we, did discuss the Alien Enemies Act, the Alien Enemies Act of 1798 permits the president to detain and remove individuals, foreign nationals of a country with which we're at war, or alternatively, individuals who have participated in a foreign invasion or incursion into the United States. And, this came to the fore when the Supreme Court overruled Judge Boasberg's finding of venue in the U.S. District Court for the District of Columbia with respect to a class of individuals who had been identified as Tren de Aragua and removed to El Salvador. I'd like to hear your opinions on that case and the court's decision and the president's use of that authority.
Well, I think the most important thing about the Supreme Court's decision is I guess it's twofold. One is the court was emphatic. This is a 9-0 ruling, even though it was reported as a 5-4 decision for a reason I'll get to in a moment. But on the important constitutional point, which is that the aliens, and we're talking again about, as you've described, aliens who were said to be members of Tren de Aragua. I think there is some component of it is also MS-13. But with the Alien Enemies Act, we're talking about the Venezuelans in particular, the Tren de Aragua members. The court said that they have due process rights, which means they have a right to notice that the government is taking action against them and to be heard in some forum. There's a lot of case law for the proposition that that's probably the court, although there have been, immigration proceedings in general take place in the Justice Department, but there is at the end of the rainbow, at least an appeal to a circuit court. But what I think the court was very clear on is that the Trump administration can't do what it has done, which is, basically load people on planes without telling them why they're being loaded onto planes and then transport them to a foreign country where they're lodged in a prison that has a very dubious track record, according to our own State Department. What the court is now saying is that they have a right to be told that they're being deported and that they will have a right to challenge whether they are actually cognizable under the proclamation, which is a lawyerly way of saying, are they really members of Tren de Aragua or not? That would be something they'd be allowed to challenge in court.
I would note that the application that the Justice Department filed with the Supreme Court, they were very clear about that. Judicial review is plainly available, but, it's right church, wrong pew. It's not before, Chief Judge James Boasberg in the District of Columbia. It's in habeas under the Great Writ in the place where they're being held, and they're all being held in Texas. And so, that was the place that the government was arguing they should have their right to be heard, and that's what the majority actually held.
Yeah, that's the 5-4 majority. I would just say, Art, that the Trump Justice Department's application has evolved, or at least its position has since the beginning of the case. So at the start, what they basically said is the president has invoked the Alien Enemies Act of 1798, and that implicates foreign relations and national security, and therefore it's none of the court's business, which is why they took the position that they could load the people on planes. Then they got kind of kicking and screaming to the position that, oh, well, okay, yes, there are cases that say that they're entitled to an opportunity to be heard. But even in making that concession, the government wouldn't concede that they were entitled to notice, because obviously if you made that concession, you would be confessing that you shouldn't have put them on these planes in the first place, although it's a pretty absurd position to say that people have an opportunity to be heard, but you don't have to tell them that they need to effectuate that opportunity in the first place. So now they're finally at the position where they're conceding that these people have habeas rights. And as you point out, that is what the divide in the court was. The majority decided they needed to bring the cases where the people are detained, because that's what habeas is. The defendant in a habeas case is the custodian of the person who is detained. The minority had agreed that the case could be brought under the Administrative Procedure Act, which is why they thought they could file a lawsuit in front of Judge Boasberg in Washington. So that's where this is at. I think the invocation of the Alien Enemies Act was attractive to the Trump administration because the president and his advisors believed that they might have an argument that the courts couldn't get involved, which is why they had the presumptuousness to put the guys on a plane. It's now clear to me and to everyone, including the administration, I think, that that is not the case. That is, these guys are going to have a right to challenge the designation as alien enemies, which in these facts, in this scenario, means they get to challenge whether they're actually members of Tren de Aragua or not. I would suggest, I'd be interested to know what you think of this, because you're much better informed on this stuff than I am. But I thought that Judge Boasberg made a good suggestion during the litigation, which is that the Alien Enemies Act invocation is constitutionally fraught, and statutorily so, because there's some case law for the proposition that a court would have the authority not only to review a question like, is the person a part of Tren de Aragua or not, but whether there actually has been an invasion or a predatory incursion. That there's a case in particular written by Justice Frankfurter back in the 1948, I think. It's the Ludecky case, where he basically says that there are justiciable standards in this statute that a court can render decisions on. In Ludecky, the issue was whether there was still a war going on. Congress had declared war, obviously, in the Second World War, but the case that we're talking about arose in 1946. So it was a year after Germany had been conquered, but it was before we had any armistice or any settlement. And the court decided that it could review whether there was still a war going on or not, but that it would not countermand Congress, and basically decided that Congress had declared war. And since Congress hadn't done anything to undeclare the war, it was going to assume the war was still going on. And that reasoning will be used with respect to the Alien Enemies Act to say, if you can look at whether there's a declared war, you can also look at whether there's an invasion or a predatory incursion. What Judge Boasberg said is, why do you want to buy that problem because it could go against the government, since there may be some profound questions about whether Tren de Aragua is actually, what it's done here is on a scale that could be considered the equivalent of an invasion or a predatory incursion by a foreign power. What he says is the president has also designated Tren de Aragua and MS-13 as terrorist organizations. And there's a lot of law for the proposition that once the government, through the State Department, uses that process to designate an outfit like Hamas or Hezbollah or now Tren de Aragua and MS-13, once it makes that determination that they're a terrorist organization, that's it. The court is not going to look behind that. A court is not going to second guess that designation. So what you would have to prove in the habeas, if you invoke the terrorism designation instead of the AEA, you would have to prove the same thing. Namely, are they members of Tren de Aragua or not? But you wouldn't have to worry about getting into all this stuff about, like, is this a war power? Was there an invasion? Is it a predatory incursion? Was the statute properly invoked? I think they'd have an easier time of it under the terrorism exclusion, because if you can tie them to an organization that the State Department has designated as a terrorist organization, they're gone under the immigration laws.
Well, it's interesting because, in the president's proclamation, he talks about the ties between Tren de Aragua, TDA, and the Venezuelan government, the Maduro government in Caracas, Venezuela. And, it's funny because, if you talk about Tren de Aragua in this country, you follow the reporting on it, it's a bunch of guys running around with AR-15s in an apartment complex in Aurora, Colorado. But it's important to note the fact that the Biden Treasury Department actually designated them as a transnational criminal organization based upon the activities that they've engaged in South America against some of our key allies in South America, Chile and Colombia, and, what they've done there. And in essence, what the president, is saying is that their presence, their activities, their entry into the United States is part of a larger Venezuelan government plan. And, again, if you look at Aurora, Colorado, or the other instances of Tren de Aragua activity here, it's, street crime, albeit very sophisticated street crime. When you look at what this organization has done in South America, it becomes a lot more clear. In fact, the same day that the Biden Treasury Department designated them as a TCO, transnational criminal organization, the State Department put $12 million worth of bounties on the heads of the three leaders of Tren de Aragua. And the reason that they did that was not because of anything that TDA was doing in the United States, but rather because of what they were doing in Colombia. And, understanding the fact that, for example, TDA members are alleged to have dressed up in Chilean army uniforms and grabbed a Venezuelan oppositionist from an apartment in Santiago and then executed him in a field and left his body. That appears to be something that they actually did at the behest of the Maduro government and, lends a lot of credence. And again, during those habeas actions, to the degree that the government is called to account for why this is an invasion, I think a lot more of that is going to come out. And it confuses me, why our media outlets don't actually talk about what TDA has done abroad and about the impact that it's had on our regional partners and could potentially have here in the United States. So I think that's a great point. And, this will be a great opportunity. And by the way, when you were talking about the evolving views of the Trump administration, I was reminded of William Hurt's line in The Big Chill, "I'm evolving. I'm constantly evolving." One of those things that, good lawyers do when they do their work. But Andy, thank you so much. There's a famous saying, no man should meet his hero. And this certainly isn't the first time that we've had the opportunity to talk, but it's probably the most expansive one. And I'm grateful for the opportunity and the time that you've spent on Parsing Immigration Policy for the Center for Immigration Studies.
Well, I certainly appreciate that, Art. And I would note that it's the second time we've had, you're right, this is a longer conversation, but it's the second time that we had a conversation. And the first time was I was guest hosting a radio show on Fox. I think it was Guy Benson's show, if I remember. And there was a major immigration controversy at the time. And Fox asked me, can we get a guest on this? And I said, there's only one guest I would trust to consult on something that was this kind of a mix of law and policy, and you were the guy. So I thought that then, I think that now, and I really appreciate the time.
Well, thank you. I'm going to clip that and send it to my wife and siblings. So truly an honor. Thank you so much for being with us today.
Thanks, Art.
This has been Parsing Immigration Policy, a podcast of the Center for Immigration Studies, and I've been Andrew Art Arthur, resident fellow in law and policy at the center, pitch hitting as guest host for our executive director, Mark Krikorian. Thank you all so much for tuning in, and have a great day.